Welcome to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. Remember, the answers given on this show do not constitute legal advice and do not create an attorney-client relationship. For legal advice, you can call the office anytime at 1-800-DeWitt-Law. That's 1-800-DeWitt-Law, or visit DeWittLaw.com. If you want your legal questions answered on this show, send those questions to ask@DeWittLaw.com. That's ask@DeWittLaw.com. We are here every Sunday morning at 10 a.m. talking about Florida's legal issues and how they affect you. I'm John Bustecker, and across from me, just like every week, is attorney Moe DeWitt of the DeWitt Law Firm. Good morning, Moe.
Happy Sunday to you, John.
Happy Sunday to you. Did you celebrate Flag Day this week?
I did not.
You did not? Oh, man. I celebrated.
I should have, though.
Yeah, I did. I was waving my American flag all over the place on Wednesday.
Well, good for you.
All right.
I'm glad somebody around here celebrated.
Well, Mo, before we get started today, tell us about this free cruise giveaway that you're doing.
Yeah, so we're doing a can't talk this morning. A free cruise giveaway for any teachers out there. So if you're a teacher, or if you know a teacher who you think deserves a free cruise, you can go to Just Call Moe, with an E, M-O-E, justcallmoe.com, and nominate them right there. And then at the end of the month, we're going to pick a winner and send a hopefully deserving teacher on a cruise. Yeah.
I know there's a lot of entries so far. So like Mo said, go to justcallmoe.com. There's a little tab up there that says win a cruise. It's pretty simple. You can either nominate yourself or nominate a teacher you know, and you're going to give them a free cruise somewhere, and you're going to join them, right?
If they'll have me.
Really? Would you go if somebody asked you to go with them?
I'll go on a cruise anytime. I'm always looking for an excuse for a vacation.
That'd be pretty fun, right? You been on a cruise ever, Mo?
Yeah, I've been on some cruises.
Okay, all right. I'm not a big fan of cruises, to be honest with you.
They're different. It's a different experience, but they're good for what they are.
All right. Well, so let's get into it, Mo. Like I said earlier, we talk about Florida's legal issues and how they affect you. There's actually a national case going on right now. There's a case in Ocala that has made national headlines involving a white woman who shot and killed a black mother of four. Have you been following this case?
I have been. And before we jump into the legal cases, we probably should say Happy Father's Day to all the fathers out there listening.
That's right. Right.
So, and if you didn't know today was Father's Day and you have a father, go give him a call and say hello.
Yeah, and if you need to go get a card, maybe go out and get a card as well.
Absolutely.
You got one more day to do it.
Well, no, it's today.
I'm saying you got today.
Oh, you got today. I see.
Yeah. They're going to be on clearance tomorrow, so go out today and get that Father's Day card. But yeah, let's go back to this case. So there's this case in Ocala. It's made national headlines. This actually happened. The incident happened on June 2nd. Woman named A.J. Owens. She was killed by her neighbor, Susan Lawrence. The neighbor has been charged with first-degree felony manslaughter with a firearm, as well as culpable negligence, battery, and 2 counts of assault. But it sort of took a few days before all of this woman was charged, because how this sort of transpired was, and I should say allegedly, because this is all sort of still coming out. It had been an ongoing dispute between these neighbors for, I guess, years.
Yeah.
And so
there's been a history here, is my understanding.
Yeah. And so A.J. Owens, her kids had been playing outside, and this neighbor, her name, as I said, was Susan Lawrence. She had sort of antagonized them, once again, allegedly, called them names, called them racial slurs, apparently, threw a skate at one of them, I guess. And so A.J. Owens went to confront this neighbor and knocked on her door. And while she was knocking on her door, this other woman, allegedly, Susan, shot through the door and killed her.
Right.
In front of her 9-year-old son.
It's just horrific.
Yes. Yeah. And so when 911 was called and the police came out, the deputies came out, they didn't arrest Miss Lawrence right away because of castle doctrine and stand your ground and all that. And so I want to get your sort of legal perspective on this, because this woman was eventually arrested a few days later.
Yeah, now she's been arrested and charged. I believe she's still in jail, pending trial at this point until she can bond out. But stand your ground and castle doctrine are all based in self-defense, right? So you have to have a reasonable belief that you're in great bodily harm or have the potential threat of death when you're using deadly force. And so when you have somebody that's on the other side of a door, a closed door, and they're not trying to make their way in, they're just knocking on the door, you can't just shoot through the door. You can call 911 and say, hey, there's a suspicious person out here, or there's a confrontation of some kind. But until they try to break into your home, until they cross that threshold into your home, you cannot use deadly force against them. Now, castle doctrine basically presumes that if somebody breaks into your home, that you have a reasonable fear that they would be trying to inflict great bodily harm or kill you, essentially.
And you mentioned calling 911, calling police. There has been reports in this case where Susan Lawrence and maybe the other woman as well, I'm not exactly sure, AJ Owens, they had called police on each other in the past. It wasn't like neither one, or at least one of them, hadn't at least called 911 in the past and reported incidents. So it wouldn't have been unheard of to call again.
Right. I mean, there's obviously an ongoing history here. But, we've seen a lot of these cases lately where somebody's turning around somebody's driveway and they shoot and kill the person, or they shoot through the door. And I think there's a bit of a misconception where if somebody's on your property, you can just shoot and kill them. And that is not the law by any stretch of the imagination. So, if you're going to own a firearm, you really need to know what the law is and when you can properly use it in self-defense. Now, I've also heard that the woman here may have had some mental health issues. I haven't confirmed that. That's also allegedly, but some people have conveyed that to me. So that may factor in here a little bit as well. But until, the woman knocking on the door, broke through that threshold to the home, the person inside the home does not have the right to legally shoot and kill that person. They have to cross through that threshold for the castle doctrine to apply, because, again, it's all rooted in a self-defense principle. It's not just, somebody's on my property, I can shoot and kill them. It's that I have a reasonable fear. And again, the fear has to be reasonable.
I've heard you talk about that before, this whole idea of reasonable fear, because,
right.
I mean, anybody could say, well, I was scared. I was scared. But you've said this in the past, not just on this show, but I've heard you on other radio shows as well, where you say it has to be a reasonable fear that maybe if you heard this maybe in a courtroom or somebody told you the story, well, yes, that's a reasonable fear because, like you said, somebody broke in. I mean, anybody can say they're afraid, even if you're, in the lawn in the front yard. Well, that's not a reasonable thing to be afraid if you're 100 feet from somebody sometimes.
Yeah, exactly. And so, you can't just have a UPS driver who you say aggressively knocked on your door, so you're afraid. It has to be reasonable. And I think there was another case a little while ago where the guy tried to argue, or the person tried to argue, that they were afraid because of X, Y, or Z reasons, but it just was not reasonable. So, if they're knocking aggressively, it doesn't matter, right? It has to be reasonable. And, typically, especially with the castle doctrine, they have to break into the home. I mean, that's when the reasonable fear applies. So these cases where people are knocking on the doors, standing on the porches, turning around in driveways, standing on the property, is just not a reasonable fear unless there's some sort of threat there, unless there's a viable threat, like somebody's coming at you with a gun or a knife or, something along those lines, and that would present a reasonable fear. But here, it just doesn't seem like it applies.
What about on the law enforcement side? Because it did take several days before the deputies or I think it's the Marion County's Sheriff's Office actually arrested Susan Lawrence. Is that typical, where it would sometimes take a little while?
Well, I wouldn't say it's typical, but I think, police agencies these days, especially with cases that are kind of highly publicized, kind of want to do their due diligence and make sure that they're doing the right thing, especially, when you arrive on a scene like this. Obviously, it's very hectic. It's very chaotic. There's going to be multiple witnesses. Some of the witnesses are family members, and they've just witnessed a murder. So it may be difficult for them to calm down to a sense to where they can be interviewed in order to get all the information that they need. So I think it's really a matter of just doing their proper due diligence before arresting somebody, because the last thing they want to do is arrest somebody and then have to drop the charges because they didn't, get all the witnesses' statements and didn't really understand what was going on.
So when I started this whole conversation, Mo, I mentioned that Susan Lawrence, she was charged with first-degree felony of manslaughter with a firearm. Why is that the charge? Why is it not like a third-degree murder or a second-degree murder? I mean, I understand why it's probably not first-degree murder, but why is it a first-degree felony manslaughter?
Well, I think at this point they probably went with a lower murder charge, and then they could always amend the charges. They could change it to second-degree murder as they get more of the evidence and more witnesses. It's all going to depend what the prosecutor, what the state attorney's office believes that they can prove in a court of law. So they may increase the charges of second-degree murder, but then have what we call lesser included offenses, where they can also ask the jury essentially, did the prosecution meet the elements of second-degree murder? If no, did they meet the elements of manslaughter? If no, did they meet the elements of involuntary manslaughter? And then they can go down and basically choose which one they want to do. And, that's more of a strategy decision there. There can be some risk with overcharging, and we've seen that before. And sometimes you can confuse the jury by doing that. So you have to be kind of careful. But ultimately, I think it'll be a strategy decision. Obviously, it's probably not a first-degree murder, premeditated murder. But, it probably falls more of a manslaughter or second-degree murder. Involuntary manslaughter is where you have a negligent act that leads to somebody's death, like you throw a rock and it just comes down on the other side of the fence and hits somebody in the head and kills them. I don't think that's really applicable here, so I think we're probably looking at more of a manslaughter charge or a second-degree murder charge. But ultimately, it's up to the state attorney here to review the evidence and see what they think they can prove in a court of law, and they'll be the one to make that determination when moving forward with charges.
All right, Mo, let's move on to another case that kind of made headlines in Central Florida this last week. A little closer to home this time. There was a police officer, Orlando police officer, who was, I think, driving to work.
Oh, yeah.
Driving a little fast to work. He was going, I think, 82 in a 45.
That's pretty speedy.
That's going fast.
Yeah.
And so driving through Seminole County, I believe somewhere near Oviedo, and a Seminole County deputy pulled him over.
Yeah.
And I guess the Orlando police officer didn't really want to deal with that at that time. And he basically said, I'm not giving you my license, and sped off to work.
Yeah, that's a crime.
Uh-huh.
I mean, first of all, I would say it's fairly rare for a marked unit to pull over a marked unit from another agency, unless they're really doing something.
And
wrong.
Going 82 and a 45 is basically double the speed limit.
Right. So there, I think there's probably some legitimate concern that what's going on here. This is clearly a safety issue, and he did not have his lights and sirens on at that time.
And I should mention this was all captured on body cam, so that's
Right.
how this kind of came to light.
Yeah. And then, once the Seminole County officer, kind of not chased him, but followed him, he eventually pulled over, got out of the car, was really kind of irreverent and say, what does it look like I'm doing? I'm going to work. Not that that's any excuse for going double the speed limit, especially without your lights on. I mean, if there was an emergency and he had to get somewhere and he activated his lights and sirens,
Yes.
That's one thing.
They probably wouldn't call you all the way up from Seminole County to come lights and
That's
sirens.
another issue, obviously. And then he got back in his vehicle and took off. So-
Which is like leaving the scene of a crime, right?
Well,
Or
yeah, I mean, basically,
eluding.
Yeah, you're fleeing and eluding a law enforcement officer. You're not following a lawful command. There's all sorts of things. So
yeah, he was charged. So the officer was charged with fleeing a law enforcement officer, reckless driving, speeding, and resisting arrest.
Yeah. So he's got a slew of charges to deal with there. I think he's been suspended at this point.
Relieved of duty is how they is how the Orlando Police Department described it.
All right,
which is kind of the same thing.
Okay. So yeah, he's in a world of trouble there. I'm not really sure why he thought that he could speed. I mean, the silly thing here is if he had just pulled over, said, "Hey, really sorry, I didn't realize how fast I was going," or whatever it may be, he would obviously be issued a citation, or may have been issued a citation, and then he may have had some disciplinary action, but he wouldn't be facing criminal charges and in nearly as much trouble as he's in now.
And he might lose his job over this too, depending.
I would think he probably would, frankly. I mean, he kind of, when he got pulled over, he really doubled down on, I'm allowed to go double the speed limit.
Yeah.
And, I don't know what you're doing here, officer. Why you're hassling me is kind of the way he approached it.
But you're absolutely right. I think if you just like sort of take that ticket, it's probably a big fine. You might even not be able to drive as a police officer for a little bit because of reckless driving, how fast he was going. But you're probably not going to lose your job over it. But now you might, everything you've kind of worked for the last umpteen years of your life may have now you've sort of jeopardized that just because you didn't want to get a ticket.
Yeah, no, absolutely. And I mean, I think really his attitude is kind of what got him in a lot of trouble.
It's a bad look.
Yeah,
it's a bad look.
all
So,
around.
all right, Mo, we got to take a little break. Don't go anywhere. Don't speed off anywhere.
All right, I'll try not to.
All right, we'll be right back. If you got questions, send those to ask@DeWittLaw.com, and we'll try to answer them right here on the show.
Story time. So I want to tell you a little story about a call I got about a year ago. This guy gave me a call. He was just in a car accident. And I talked to him for a while. I told him what to do. Told him he needed to go seek medical treatment and get checked out. He said, thank you. I appreciate your time, but I'm not going to hire you. So not a problem. If you have any questions, concerns, let me know. Happy to talk to you anytime. About 2 weeks later, I was actually in the Bahamas. About 2 weeks later, he called me back and he goes, spoke to the insurance company. They're offering me $770 and they're saying I'm 30% at fault for the accident. You're hired. Sent him the paperwork, got him signed up. That was about a year ago. Today, we just settled his case for $100,000. The insurance company wanted to pay him $770 to resolve that claim. And this is just a prime example as why you should never settle with the insurance company that soon after an accident. You don't know what your injuries are. You haven't gotten checked out by a doctor. You don't know if you're going to need surgery or if there's a tear in a ligament or something more substantial. So when the insurance company offers you quick money after an accident, typically they're offering you pennies on the dollar to go away. And the last thing they want you to do is to hire an attorney because they don't want to pay you the fair compensation that you deserve.
Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. Here on the show, we talk about legal issues here in Florida and how they affect you. I'm John Bustecker. I'm with attorney Moe DeWitt of the DeWitt Law Firm. If you have legal questions, send those questions to ask@DeWittLaw.com. That's ask@DeWittLaw.com. You can always call the DeWitt Law Firm at 1-800-DeWitt-Law. Mo, are you ready for some questions?
Let's do some questions.
All right. This one came in this week. It's a little bit of a long one, so be patient with me here. All right. My ex-husband lost his $150,000 a year job. For 1 year afterwards, he lived off his 401k and told people he was retired. He purchased a camper, a boat, several cars, and went on vacations.
Okay.
Then he got a lower paying job and filed for a child support modification after not working for a year. My child support was significantly reduced. Question: can my ex-husband's behavior and spending spree be taken into consideration if I file for a modification of child support?
So typically, no. I mean, child support is kind of based on four primary factors. It's based on the number of overnights you have with the child, the incomes of each party, who pays for the health insurance, and who pays for any daycare costs if the child's in daycare. And so, one thing is that he waited a while. It sounds like he waited a year or so to file a modification until he got that new job.
Yes.
So the court can only go back to when he filed the modification to adjust the child support. That's something we've talked about on the show a lot before. And, if you ever lose your job or have a substantial reduction in income, you want to file a petition for modification right away because the court can only modify the child support from that date forward. And so the real test here is, he did lose his job and he went on a spending spree and he had the money to do it. That was in savings, possibly
401k,
yep. Something like that. But when he got the new job, the real test is going to be, is he deliberately underemployed? So did he make a good faith effort to get a job with a similar income to the job that he had before? And if he didn't, or let's say, he quit his corporate job and now he's working for his buddy and, maybe there's some fishy things going on there with the income, that's where you can argue that they're deliberately underemployed and possibly argue that he should be imputed more income, which basically means for child support purposes, the court's going to pretend that he makes more income to calculate the child support. Otherwise, if he legitimately lost his job if he went out there and pounded the pavement, looked for any possible job in his field based on his, skills and qualifications, and, he had to take a substantial reduction in income, then the child support's going to be modified accordingly. Obviously, they're not happy about the reduction in child support, but that's just the way it is. And so even though, he spent a bunch of money and kind of went a little crazy with the spending, your spending is not necessarily considered as part of child support. The only other argument you could possibly make is if there was a large amount in savings, you can do what we call impute income off of it. So a reasonable rate of return on those items. So if he was spending a bunch of money, you could try to argue, well, he was just really moving money around so that they couldn't impute a reasonable rate of return. Typically, though, that's not going to make a huge difference into your monthly income because, it's a fairly low percentage of interest and probably not, tons of money, I would guess. So, the best argument is probably to look at whether he really, is underemployed or not, or if this is a legitimate job and he's really only making $80,000 now.
So there is a bit of a follow-up question here. She said, since he got this $80,000 a year job, he's actually gotten a promotion since the last modification. How can I find out about his new income amount and whether it's worth filing a modification?
So that's one of those funny things in Florida. So other states have a requirement where every year, every 3 years, you have to report your updated income. In Florida, we don't have that requirement. So the only way to actually find out is to file the petition for modification. And basically, you file the petition for modification along with a request for the financial information. And they'll typically have 45 days to provide it. And then once you get that information, if they did receive a substantial promotion, you can move forward. If they didn't, you have to dismiss the case if it's still the same. So it's you kind of have to act on a hunch and sort of file and see what's there. And that's about it.
All right, Mo, we got to take another break here. We'll be right back. But if you got questions, send those questions to ask@DeWittLaw.com. We will answer those questions right here on the show. See you in a bit.
Pigs get fat and hogs get slaughtered. We just settled a case for a client for $40,000. Client said they were okay with settling between $25,000 and $30,000, but we wanted to push it to get them the maximum value possible. And this client was super cool. They let us do that, and they got a great result because of that. So remember, pigs get fat, hogs get slaughtered.
Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. Here on the show, we talk about legal issues in Florida and how they affect you. I'm John Bustegger. I'm with attorney Moe DeWitt of the DeWitt Law Firm. If you have questions, send those questions to ask@DeWittLaw.com. That's ask@DeWittLaw.com. You can always call the DeWitt Law Firm as well at 1-800-DeWitt-Law. And I think, Mo, there's a way to leave a voicemail, too. What's that number?
It's 407-536-6737 or 407-53-MOSES. And you can leave a voicemail there, and we'll play it right here on the air.
All right. We got lots of questions this week, Mo. Are you ready?
Yep, let's do it.
We're going to do some rapid fire, I think, here.
Oh, boy.
Here we go. First one. This is from Rebecca. She lives out in Oviedo. So maybe she saw that police officer speed into work the other day. Who knows? All right.
Hopefully not, but yep.
Question is, he was probably going so fast she didn't even see him go by.
There you go.
Here's her question. This is from Rebecca. Can I sue my landlord for failing to fix a persistent mold problem in my apartment that is affecting my health?
Well, you can, but you have to establish a few things to do that. So number one, if there's a mold problem that's affecting your health, you need to move out of the property as soon as possible. Because one of the defenses that if you do sue them, the defense is going to use is that, well, if it was so bad, why didn't you leave the property? And obviously that can be a little tricky, especially given the financial situation of having to leave an apartment and find a new place and get set up. Depending on the type of mold, your furniture and belongings may need to be cleaned or may have to be destroyed. But you also need to get the mold tested because not all mold is harmful. So there's a number of companies out there that will do mold testing that you can come out and test the air quality and see if it's at a level that is affecting your health. Because one of the issues with mold cases is you have to show that the mold is causing whatever symptoms that you have. and that it came from that apartment. And there used to be some, I'll call ridiculous case law, and it was out of Miami actually, where there was a person who worked in the courthouse down there and was having some adverse effects to mold. And the doctor actually pulled a piece of mold out of the person's nose that matched the same type of mold from the courthouse. And the court said, well, that wasn't enough to prove causation. That the mold, even though it's the same type, that type could have grown anywhere. So how do we know it came from the courthouse?
Because there's lots of different kinds of mold too, right?
There is. So the standard is not quite that crazy anymore, but it still does take some effort to actually prove the case. But the first two things you have to do if you're in this situation is, number one, get a mold test done right away. And then if it is positive, move out, get your stuff out of there and get into a new place, and then, establish your claim. You should, of course, let them know as well, give them an opportunity to try to rectify it. I'm assuming they've already done that here. But they need to have somebody properly come out and treat the mold. A lot of times, I think just because it's Florida, apartment complex will say, we'll just send the maintenance guy over there with a bottle of bleach and say, here it's fixed, and it's not. They're not fixing the root of the problem.
Yeah, what you can see is probably a tenth of what might actually be underneath anything too, or inside a wall or whatever.
Yeah, especially if an air handler's been leaking, or something along those lines. It builds up, it causes mold, or something else. Anytime there's water, obviously mold can develop. So yeah, it needs to be treated properly.
All right, Mo. Next question. This is from Ben. He lives out in Tavares. So Ben said, I was recently pulled over for suspicion of driving under the influence.
Okay.
What are the penalties for a first-time DUI offense in Florida? And actually, how can they, can he fight that at all as well?
So was he actually arrested, or was just pulled over?
He said he was pulled over for suspicion. Let's assume he was arrested for it.
All right. Well, hopefully he wasn't, and hopefully he wasn't driving drunk, because number one, just don't do that. But there are minimum mandatories for first-time DUIs, and then they increase the more DUIs you get. You shouldn't get one, but, if you get multiple, the punishment becomes worse. Now, you should always hire an attorney anytime you're facing any sort of criminal charges. And I don't know the mandatory minimums off the top of my head. I think it's something along the lines of 6 months probation. I think your driver's license is suspended for a period of time. I think you have to have an interlock device placed on your car. I think the car may have to be impounded for a period of time. I think there's a fine to Mothers Against Drunk Driving, or like a donation you have to make. There may be a few other things in there that I'm forgetting. But it's not good. I think you've probably heard some statistics where, a DUI costs something like $10,000.
Oh, it's a lot. I've had friends that have gotten DUIs, not here in Florida, but where I grew up, and it costs thousands of dollars.
Yeah, not even just including what the court orders you to pay as far as probation fees and court costs, and this, I think you might have to take a class of some time too, an alcohol evaluation class, I think. So it's very, very expensive. It's much cheaper to order an Uber or get a Lyft.
So much cheaper.
Yeah. But there are mandatory minimums that you're typically facing for a first time DUI. Now, depending on the circumstances, if you hire an attorney, sometimes they can get it negotiated down to what we call a wet reckless, which is basically reckless driving while you were drinking. It's a little bit of a lower crime than a DUI, and it will have different penalties. But rule is just don't do it.
Yeah. All right, Mo. Let's move on to the next one. This is from Natalie.
Okay.
She lives out in Winter Park, not too far from here.
No.
I'm considering filing for divorce in Florida. What factors does the court consider when determining alimony? Now, we get this question a lot. I hope if you listen, week after week, you might, I've heard that answer. Well, we have a lot of people that, people get divorced, people have questions. So when they send them to us, we answer them. So that's why we're getting this question again. What factors does the court consider when determining alimony?
Yeah, alimony is probably one of the most disputed issues in any divorce, because nobody ever wants to pay alimony, and anybody who's receiving alimony never thinks it's enough typically. So those are generalizations, but in most cases, that's kind of the situation. And so, the court, from a legal perspective, is looking at what we call need and ability to pay. So they're looking at the person who's receiving the alimony. What kind of need do they have on a monthly basis? Meaning, what are their kind of basic expenses? Not luxury vacations and things like that, but what are their kind of basic needs to survive, offset by, of course, their own income? And then what does the person paying the alimony have the ability to pay after he or she pays all of their basic expenses? And When I say basic expenses, it's going to be based on the standard of living during the marriage. So if you had during the marriage, if you live very frugally, then your expenses would continue to be frugal. You can't just say, oh, well, we lived in like a 2-bedroom apartment, but I'd really like to get a 6-bedroom house over in Windermere. You can't do that. It's kind of based on what historically has, been going on in the marriage. And same thing on the other side. If you were going on luxury vacations and things like that, that standard of living is theoretically supposed to be maintained. Now, I always say theoretically because anytime you take one household and split it into two and you're relying on the same amount of income, it just can't support, 2 households. So you have to kind of look at, okay, how do we get as close as possible to that lifestyle? And that's one of the things that the court's going to look at as well. And there are a number of different factors that they look at. And of course, they're going to look at the length of the marriage, depending on how long you're married, is going to determine what type of alimony you're entitled to and how long you're entitled to receive alimony. Typically, if it's a very short-term marriage, you're looking at alimony just kind of to get back on your feet, or maybe alimony just while the case is ongoing, what we call temporary alimony. If it's a longer-term marriage, then you could be looking at alimony for a longer period of time.
What if there's a large windfall after alimony is determined? So let's say somebody makes $100,000 and then the alimony is determined, but 6 months later that person wins the lottery for $20 million. Does the alimony change?
So typically it does not, because again, it wouldn't be based on the standard of living during the marriage, right? It's not based on marital efforts. If you win the lottery after your divorce, that's your money. Now, the only time that could possibly come into play, and it's going to be a very slight modification, but would be, let's say that somebody had a high need, but the person who was paying didn't have the ability to pay that full need. So let's say their need was, I'm just going to use round numbers, $1,000 a month, but the person only had the ability to pay $500 a month. Well, now they could go back and argue, okay, now you have the ability to pay the full $1,000 a month versus the $500, but they're not entitled to a direct portion of those proceeds, if that makes sense. It's just that now that they would have the ability to pay the full amount of that need going forward. But that's a very rare situation. I think I've only seen it happen once or twice where they actually kind of modify the alimony to increase like that. But it is possible.
I'm going to ask you one more question on alimony because I'm curious now. What if during the marriage one of the spouses was working on something, let's say a novel, we'll say, or a piece of art, and they get divorced, but then afterwards, the novel hits and is a bestseller, and all during the marriage they were struggling together, and now somebody gets a big windfall because their book is a bestseller. Does that get factored into alimony?
So that's dealt with as part of the divorce. So that's intellectual property that was created during the marriage, just like, a business could be created during the marriage and would be subject to equitable distribution, or even just buying a house, right? It's an asset that you guys have. The difference is at the time you're getting a divorce, it doesn't really have much value to it. So, whether a court's, finalizing your divorce or you reach a settlement agreement, it has to be dealt with appropriately. And that's where, having lawyers who are experienced in family law and divorce law can really make a big difference with those kinds of things. And we've dealt with it before with, music and books and all sorts of different intellectual property, frankly. But it has to be handled as part of either the final judgment or the marital settlement agreement. And, sometimes they'll say that any proceeds off of that are split equally, or sometimes they'll award it to one person or the other. But that's what's going to control it ultimately. Now, the dangerous thing is if it doesn't say anything at all, and then there could be an argument to go back and try to set aside the marital settlement agreement or set aside the final judgment because maybe one party didn't disclose it properly or wasn't handled properly. And that's when it can become a big mess.
And Mo, you have a whole book on divorce, correct?
We do. So it's DeWitt's Guide to Divorce. And, it's not an in-depth book. It's not a legal book. It's really a book out there for anyone who's thinking about going through a divorce, maybe has a friend who's going through a divorce. And it can just be a tricky time. You don't really know who to trust. You've never been through it before, hopefully. Everything's just kind of scary, and it seems like, the world's kind of against you. So it's really a guide to kind of show you what the process is, help you understand the steps, and just kind of give you some guidance as to how to get through the divorce. Because ultimately, you will get through it. You'll see the other side. You'll kind of rebuild your life or have a new life or whatever it may be. But going through that process is a difficult time for a lot of people. So If you want to get a copy of the book, we have it free for WDBO listeners at DeWittDivorce.com. You can download a PDF there, but it's also available on Audible. It's on, I think, Spotify and Apple Podcasts as a podcast. And maybe
you can also go to shop.justcallmo.com and get a physical copy.
Yeah, if you
we'll
want a
mail
paper
it to
copy
you.
there. It's also on Amazon, too, if you want a paper copy there as well. But DeWittDivorce.com is where you can download a free copy.
Would you sign a copy if I brought one to you, Mo?
Sure. As long as my hand's not cramping, I'll sign as many copies as you bring.
All right, Mo. Next question. This is from Ava. Speaking of divorce, this is from Ava. She lives in Kissimmee. Can I be held responsible for my spouse's debts if we decide to get a divorce in Florida?
So that's a great question. I think that's something that's often misunderstood. So just like assets, any debt that's acquired during the marriage is split equally. For the most part, there are some exceptions, but it doesn't matter if the debt's in your name or in your spouse's name. And so a lot of times when we're talking to a potential client during a kind of a divorce consultation, they'll say, well, there's nothing to divide. There's just debt. All the debt's in my husband's name. So, I assume he just is going to keep that. And that's not really the way it works. So, you're still responsible for half of the debt that was acquired during the marriage. Now, there are some exceptions, like if there was dissipation or something like that, where you're going out and, running up credit card bills on gambling or drug use or something that's kind of illicit, essentially, wasting money. That's one of the exceptions
gambling
there.
is not wasting money, Mo, is it?
If you win, it's not wasting money. If you lose, it's wasting money. And I don't think anyone actually loses forever, or wins forever. But the difficult part becomes, so if the debt's all in one party's name, then you have to offset it with another asset, because it's usually very difficult to transfer the debt over. So there are some different ways we have to deal with that. It's going to depend on the individual financial circumstances of those parties. Do they have assets to offset it? Is it something that can be refinanced? Do they have to kind of do payments over time or something along those lines? But from a pure legal standpoint, you are responsible for half of the debt that was acquired during the marriage.
What if my spouse went to college, got a law degree, we'll say, and they have $200,000 in school debt? Do I owe $100,000 of that if I get divorced?
You do, and that's one that people don't like hearing. So just like any other debt, if it's a student loan and it was acquired during the marriage, you're still responsible for half. And so, we've had cases before where they're married, the person goes to school for whatever, and then as soon as they graduate, they get divorced, and they're still on the hook for that half of that student loan. It may not be fair, but that is what the law is. So, yeah, it can be very tricky, and you have to look at it and see exactly what their circumstances are.
All right, Mo, we got to take another break. If you're listening right now, don't go anywhere, because we got more questions to answer. And if you have questions, you can send those questions to ask@DeWittLaw.com. We will be right back.
So can you still file a personal injury claim if you are partially at fault? The answer in Florida is yes. You can still file a claim even if you are partially at fault. But usually what we see with these types of things is that the insurance company or the other side, the defendant, will say that you're partially at fault to reduce their responsibility in a payout. They'll use this as a tactic in negotiations and things like that. But ultimately, you can still file a claim. You can take that claim to a court and to a jury, and it will be up to a jury to determine whether you are partially at fault or not. But you can still receive compensation even if you were partially at fault, at least for an accident in Florida.
Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. Here on the show, we talk about legal issues in Florida and how they affect you. I'm Jon Bustecker. I'm with attorney Mo DeWitt of the DeWitt Law Firm. If you have legal questions, send those questions to ask@DeWittLaw.com. That's ask@DeWittLaw.com. You can always call the DeWitt Law Firm, too, at 1-800-DeWitt-Law. Mo?
John,
You ready for some more questions?
let's wrap it up. Let's get these people's questions answered.
All right, here we go. This is from Olivia. She lives in Tampa.
Okay.
Wow, maybe she's listening to the podcast.
Yeah. We should mention you can listen online, the DeWitt Law Review on wherever you get your podcast, Apple, Spotify.
It's true. We also stream it online too. So if you want to watch us on Sunday morning, you can do that too.
Yeah, on Facebook. We should say Facebook and YouTube. I think.
Yes.
Search DeWitt Law Firm.
One of millions of people that watch us every weekend.
I think the one person might be right.
You watching yourself?
Yeah, exactly.
Here we go. This is from Olivia. She lives in Tampa. I was injured in a slip and fall accident at a grocery store.
Okay.
How do I determine if the store can be held liable for my injuries?
So that's kind of an interesting question because in Florida, the standard changed a number of years ago and then recently changed again, where, it's not just that a substance was on the ground. You have to basically show that the grocery store was negligent in some regard, meaning that basically they either knew or should have known that the substance was on the ground. So typically what that means is that there was a spill that occurred by, let's say, another customer, and it was just left there for an extended period of time. Maybe some employees walked past the spill, saw it, but didn't take any action. They didn't put any cones up. They didn't clean it up. The other way that they could be liable is if an employee actually directly caused the spill. Let's say they were dragging a trash can through the store, and the trash can had a hole in the bottom. It was just leaking, liquid, and somebody, walked down the aisle and slipped on it. So if the store employee caused it directly, then you have negligence. But if another customer caused it, the way they would be negligent would be if they didn't clean it up within a reasonable amount of time. And so this is where it can get a little tricky because you have to get all the surveillance video, not only of just where the accident occurred, where the slip and fall occurred, but basically you have to show of the whole store because you want to be able to show what were the employees doing, right? Did they have a system or a program set up where somebody was walking around and checking for spills, or were they all just in the back on their cell phones? And so that's where, some of the evidence really becomes crucial and why you have to get that surveillance video. Well, I shouldn't say get, because they won't give it to you right away. You have to preserve it. So you have to send them a preservation letter, what we call a spoliation letter, basically saying you need to preserve this evidence so that if we are going to bring a claim, we have all the evidence we need.
All right, Mo. Next question. We got so many. I can't even do follow-ups. All right, this is from Ethan. He lives right here in Orlando.
Okay.
Hometown Ethan. My employer fired me without any valid reason. Can I file a wrongful termination lawsuit in Florida?
So typically you can't. Typically Florida's an at-will employment state. So, typically you can be fired for any reason as long as it's not discriminating against a protected class. So if you can show that there's some sort of discrimination against a protected class, then you could file a lawsuit. But otherwise, if it was just, hey, we didn't get along, we didn't like you the way you worked, given that we're an at-will employment state, and I'm assuming there's no contract in place, then, they can kind of terminate you for any reason.
All right. So cut and dry on that one. Yeah. All right. So this is from Victoria. She lives in Kissimmee.
Okay.
Here we go. I was injured in a car accident caused by a drunk driver. Okay. How can I seek compensation for my medical expenses and damages? And I'm going to do a little add-on to that. Does that change it if you're hit by a drunk driver rather than just somebody who got in an accident with you? Does that change the accident at all?
Yeah, it does. Because if somebody is drunk or driving under the influence, you can go after what we call punitive damages. And it's basically damages to prevent people from doing stupid things. And so, if you have an accident like this, of course, I think everybody kind of knows you can, assuming the person has insurance or assets to go after, you can recover money for, pain and suffering, lost wages, medical bills, all that kind of stuff. But when somebody's drunk or doing something crazy or stupid like that, you can also ask for punitive damages. And that's where it becomes interesting from a legal standpoint because now even if the actual physical damages are lower, the punitive damages for them, especially if they were just blackout drunk or whatever it may be, just acting crazy, then you can go after them for that as well.
All right, Mo, we got to wrap it up.
All right. It's been a fast show. A lot of questions.
It has been. Yeah, it really has been. But if you got questions for next week, send those to ask@DeWittLaw.com. That's ask@DeWittLaw.com. And always, if you have any legal questions, you can always go to DeWittLaw.com or send an email or call 1-800-DeWitt-Law. Any of those things. Send out the DeWitt Law bat signal and Mo will come looking for you. All right. We will